Welcome back. There is a particular kind of fraud that never makes the news. Quiet, domestic, dressed in family love and ink on paper. What makes this story worth studying is not the betrayal itself, but the weapon used to dismantle it. A single phone call from a title company examiner who simply did her job. That call cost nothing. It destroyed everything. Welcome to Historical Manhwa. The smell hit Nora first. Not grief, not memory, not the particular sadness of a house that used to hold a living person, just turpentine. Faint, clinging to the baseboards of the hallway like the ghost of a renovation project her mother had started in 2019 and never quite finished. The contractors had stripped the wainscoting on one wall and left a raw seam of drywall compound that had dried the color of old bone. Her mother had meant to sand it. Then the diagnosis came, and the wall stayed open, like a wound that had simply accepted its condition. Nora stood in the hallway of 4114 Ridgemore Lane for the first time in 11 months, one hand resting on the doorframe, her overnight bag still hanging from her shoulder. The drive from Atlanta had taken 6 hours. She had not stopped except once, for gas, somewhere outside of Chattanooga, where the pump still had little American flag decals on the handles, and the coffee inside the convenience store had the specific burnt quality of a pot that had been sitting on its burner since 7 in the morning. She had bought a cup anyway. She had stood in the parking lot and drank it in 4 long swallows, and felt nothing in particular except a mild awareness that she was tired, and that tired was better than the alternative. The house was quiet, in the way that only emptied houses are quiet. Not peaceful. Emptied. Her mother's furniture was still in place. The floral sofa in the living room that had aged from cream to the color of weak tea. The walnut buffet in the dining room that had taken 3 men to carry up the porch steps when her parents had moved in. The brass floor lamp beside the armchair by the window that her mother had read under every evening for 30 years. The lamp was still on. Someone had left it on, and the shade had the particular golden warmth of incandescent light in a room that smelled of turpentine and closed windows, and the fading residue of another person's life. Her mother had been dead for 4 months. The estate was still technically open. Nora knew this not because she had been particularly involved in the process, but because she was the executor, a fact that her mother had noted in the will with a precision that had surprised the estate attorney who'd read it. A man named Holt, who wore his collar too tight and kept apologizing for the length of the document in a way that suggested he apologized for most things. The will was not complicated. The house on Ridgemore Lane went to both daughters equally, 50-50, with the provision that neither could sell without the written consent of the other. There was also a savings account, a modest one, and a collection of silver plate flatware that had no real monetary value, but that both daughters had been fighting over, in the polite, passive-aggressive way of adult women who had never quite learned how to argue directly, since before their mother's body was cold. The sister's name was Dana, 3 years older than Nora, lived 40 minutes away in a suburb called Claremont Hills, in a house that was large enough to signal success from the curb, but that Nora knew from the financial details Dana occasionally let slip was leveraged to a degree that would have made their mother's generation physically ill. Dana's husband, Marcus, had invested a significant portion of their savings in a restaurant concept that had lasted 14 months before the pandemic finished what the mediocre food had started. They had refinanced their mortgage twice. Dana had mentioned in passing at their mother's funeral that the property taxes on the Claremont Hills house had gone up again. Nora had nodded and said nothing, which was what she generally did when Dana talked about money. She set her bag down inside the front door and walked through the house slowly, not with any particular purpose, just walking through each room, the way you do when you are taking inventory of a grief you have been postponing. The kitchen still had a calendar on the wall, one of those charity ones with watercolor paintings of birds, open to January, because her mother had stopped being able to turn the pages by February. There were still dishes in the drying rack beside the sink. Someone had washed them. Nora assumed Dana had been through the house at some point in the past 4 months, though she had not mentioned it specifically. They had not spoken much since the funeral, which was itself a fact that Nora had not examined too closely, because she knew that if she examined it, she would find something she did not have the energy yet to name. She opened the refrigerator out of habit. Someone had cleaned it out at least. The door shelves still had the marks of old condiment rings. the faint sepia ghosts of mustard jars and salad dressings. She closed it again. She had come to the house for one reason, and it was not grief tourism. She had come because Holt, the estate attorney, had called her 3 weeks ago with a request that had arrived in her mind as a small, cold stone and had been sitting there ever since, pressing against the underside of her thoughts at odd moments. While she was reviewing a client's spreadsheet, while she was waiting for the elevator in her building, while she was lying in the dark at 2 in the morning with the specific wakefulness of someone who has a problem she has not yet decided to fully look at. Holt had called to tell her that the deed to 4114 Ridgemore Lane needed to be formally transferred into the names of both heirs before the estate could close. Standard procedure. He would need her signature on the transfer documents. He had sent them to her email. Had she received them? She had received them. She had opened the email, looked at the documents, and then, for reasons she could not have articulated at the time, she had not signed them. She had told Holt she needed a few more days to review. He had said, of course, take your time. That had been 3 weeks ago. The thing she had noticed looking at those documents was a line in the deed record that had not been there the last time she looked. Not a dramatic line, not something that screamed, a notation in the title history. A transfer document filed with the county recorder's office 6 weeks after their mother's death, bearing what appeared to be Nora's signature alongside Dana's on a deed of trust that had not been mentioned to Nora, not discussed, not referenced by Holt, not explained by anyone. Nora had looked at it for a long time. Then she had closed the laptop and made dinner. She had slept badly for 3 weeks. She was here now. She went to the second bedroom, which had been her room growing up, and which her mother had converted, gently, into a sewing room, sometime in the mid-2000s. The sewing machine was still there, a heavy old Singer on a wooden table that had belonged to their grandmother. The chair beside it still had a measuring tape draped over the back. Nora sat down in it and looked at the window and thought, with the slow, deliberate quality of someone turning over a very cold stone, about what she actually knew. She was a forensic accountant. She had been doing the work for 12 years, first for a mid-sized firm in Atlanta and then independently, as a consultant retained primarily by law firms and insurance companies who needed someone who could read a financial record the way a good radiologist reads a scan, not just for what was visible, but for the shape of what was hidden. She was not a real estate attorney. She was not a title examiner. But she knew fraud. She had spent 12 years learning the grammar of fraud, the way it composed itself in documents, the particular logic of a person who believed they were being careful. Careful people always left marks. They left marks because being careful required decisions, and decisions created patterns, and patterns, to someone who knew how to look, were as legible as handwriting. She had not signed that deed of trust. She had never seen that deed of trust until Holt's email had attached the full title history as a routine enclosure. The signature on it had her name. It had the particular visual quality of a good forgery. Not a copy, not a trace, but an imitation. Someone who had practiced. Someone who had looked at Nora's actual signature enough times to produce something that would pass a casual review. The problem with a good forgery is that it is, by definition, something a person has worked at. Effort leaves traces. Effort means there was a document from which to learn, a model, a reference. And a reference meant that somewhere in the chain of events leading to that deed of trust, Nora's actual signature had existed on something that Dana had access to. She knew what that document was. Their mother's will had been signed in front of a notary in March, 8 months before their mother died. Both daughters had been present. Nora had signed the witness page. Dana had. Stood 2 feet away and watched. She sat in the sewing chair and let herself be very still for a moment. The brass floor lamp's light came faintly down the hallway into the room, and outside the window, the evening was making the slow transition from pale to dark, the sky over the neighbor's oak tree going from the color of a bruise to the color of a bruise healing. A mockingbird somewhere was doing its late-day inventory of every sound it had collected since morning, cycling through 3 other birds and a car alarm. Nora thought about Dana's refinanced mortgage. She thought about the restaurant that had lasted 14 months. She thought about the way Dana had looked at the house during the funeral reception, standing in the living room with a glass of white wine, looking at the walls, the windows, the ceiling, with the specific expression of a person who is seeing a number. Then she took out her phone and called a man named Gerald Osai. Gerald was a real estate attorney who had done transactional work for 3 of Nora's past clients. He was meticulous in a way that sometimes frustrated other lawyers, but that Nora had always found deeply reassuring. The kind of man who would read every page of every document and then read it again, and then make a note about the things he'd noticed the second time. He answered on the 3rd ring. She could hear, faintly, the sound of a basketball game in the background, which she filed away as a detail that humanized him slightly. She said she needed to talk to him about a deed fraud situation. He turned the game off. She told him what she had found. She told him about the deed of trust, the title history, the transfer notation, the signature. She did not editorialize. She read him the document numbers in order and described the timeline with the precision she would have used on a client report. Gerald was quiet for most of it, occasionally making the low, thoughtful sound of someone whose mind is moving faster than his voice. When she finished, he said, "Do you know who the lender is on the deed of trust?" She looked at the document again. "A company called Ridgemore Capital Partners." He was quiet for a moment. "That's a private lender, not a bank." "I noticed that." "Private lenders on deed of trust instruments filed against inherited property within the estate settlement window, that's a specific kind of transaction. It usually means someone needed money fast and was using an asset they may not have had full legal authority to encumber." "Right." "You're the co-heir and executor." "I am." "Your signature on that deed of trust. You're saying that's not yours?" "It is not mine." He let that sit for exactly 2 seconds. "Okay. What do you want the outcome to be?" Nora looked at the measuring tape draped over the back of the chair. Her mother had used it to hem curtains. She could picture the specific posture of it. Her mother bent over the fabric on the floor, pins between her lips, one hand holding the tape measure, with the practiced casualness of someone who had done this gesture thousands of times. She said, "I want to do this correctly." What she meant by correctly, Gerald came to understand over the next hour, was a specific thing. She did not mean the fastest path. She did not mean the path that caused the least damage. She meant the path that was airtight, the path that, once set in motion, could not be reversed or disputed or softened by any subsequent action on Dana's part. She had spent 12 years watching people try to undo fraud after they were caught, and she knew that the undoing was often almost as damaging as the original act, if the original act had been handled badly. She did not want to handle it badly. Gerald told her the first thing she needed to understand was the nature of what had been filed. The deed of trust that appeared in the title history was a security instrument. It was not a deed of sale. It meant that someone, presumably Dana, had used the property as collateral to secure a loan from Ridgemore Capital Partners. If the loan defaulted, the lender would have the right to foreclose. The fact that Nora's forged signature appeared on it as a co-owner meant that Dana had represented to the lender that she had the authority to encumber the full property, which she did not. She had 50% of it. The other 50% belonged to Nora, and Nora had never consented to anything. Nora asked him what Ridgemore Capital Partners knew. Gerald said that was the right question. A private lender using a deed of trust against an inherited property had presumably done some title work. They would have ordered a title search, or should have. If their title search missed the estate proceedings and the dual heir status, that was either negligence or willful blindness. Either way, they had recorded a security instrument against a property that was not fully in the borrower's name, which created a cloud on the title. She asked, "What happens if Dana is now trying to sell the property?" Gerald was quiet again. She could picture him leaning back in whatever chair he was sitting in, making a note. "Has she listed it?" Nora had, in the past 2 days, searched the property address on every major real estate platform she knew, which was something she had done at 2 in the morning, after the 3rd night of bad sleep. She had found it, listed 14 days ago, an asking price that suggested Dana had hired an agent who knew the market. The listing had professional photographs, the kitchen, the living room with the floral sofa that the photographer had clearly moved to a better angle, the backyard that had looked in the photographs considerably larger than it was in reality, because professional real estate photographers always shoot the backyard on a slight diagonal. The listing noted the property was being sold as part of an estate sale. It had not noted that there were 2 heirs who were required by the terms of the will to consent jointly to any sale. "She listed it 14 days ago," Nora said. "Has she received an offer?" "I don't know." "You need to know, because if there's a purchase agreement signed and they're moving toward closing—" He paused. "That's where this gets interesting, legally." "Tell me." Gerald explained the closing process. When a property goes to closing, the title company handling the transaction runs a full title examination. They are looking for any defects in the chain of title, liens, judgments, encumbrances, competing ownership claims. A reputable title company will find the estate proceedings. They will find the co-heir status. If the deed of trust from Ridgemore Capital Partners is on the title as an encumbrance, they will note it. They will require it to be cleared before they issue title insurance. And when they see that Nora's signature as co-owner is on that deed of trust, but that Nora has not appeared in any other aspect of the transaction, has not signed any listing agreement, has not signed the purchase agreement, is not at the closing table, they will pause. "A good title examiner," Gerald said, "is going to call the second owner." Nora looked at the window. The mockingbird had stopped. The sky was fully dark now. "Would they call the police?" she said. "If they determine that a signature on a recorded document is forged, yes. That's deed fraud. That's a felony in this state. They have a duty to report it. And if the buyer's lender is involved, and the lender's collateral is based on a fraudulent instrument, that triggers a whole other set of reporting obligations." She sat with this for a moment. "So," she said, "if Dana has a closing scheduled, and the title company does their job, they will find the forged instrument. They will find you. They will, if they're doing this correctly, contact you directly to verify your ownership status and determine whether you authorized either the deed of trust or the sale." "And if I tell them I did not?" "Then they don't close. They report the fraud, and everything that happens next is Dana's problem." Nora thanked him. She told him she would be in touch and that she would need him to be available. He said he would be, and asked her to send him the document numbers so he could pull the full title history himself. She did, right then, from her phone, sitting in the sewing chair in her dead mother's house, with the measuring tape behind her head. After she hung up, she sat in the quiet for a few minutes. She thought about a conversation she'd had with Dana 2 years ago, before their mother got sick. Before any of this. They had been in Dana's kitchen, the big renovated kitchen with the farmhouse sink and the open shelving that Dana had been very pleased about, and that Nora had thought was impractical because open shelving meant that everything on it was always slightly coated with cooking residue. Dana had been talking about the Ridgemore house, about how the neighborhood was improving, about how the assessed value had gone up 23% in the past 4 years. She had been calculating out loud. Nora had been drinking a glass of water and not particularly engaging because Dana calculated out loud frequently, and the calculations rarely had any practical endpoint. Dana had said, "If Mum ever sells, that's a significant asset." Nora had said, "Mum's not selling." Dana had said, "Obviously not now, but eventually." Nora had not said anything. Dana had said, "She'd split it evenly. She's always been very fair about that." The way she had said fair, the word had arrived with a particular inflection that Nora had noted and then set aside. The way you set aside a small, wrong-sounding thing that you're not ready to examine. Fair. As though fairness was a constraint. As though an even split was a procedural obstacle rather than a reasonable outcome. She had thought about that conversation a few times since then. She thought about it now. She pulled up the real estate listing on her phone again. 14 days. If there was already an offer and a purchase agreement, there might be a closing date soon. She sent a text to an acquaintance named Bree, who was a residential real estate agent in this market, and who owed Nora a favor from a thing that had happened 18 months ago involving a contractor and some invoices, and a small amount of very targeted financial forensics that had saved Bree's broker considerable embarrassment. She asked Bree, "Can you look up whether there's an active purchase agreement on this address?" Bree replied in 12 minutes. "Yes. Offer accepted 10 days ago." The listing had gone to pending status. Closing was scheduled in 17 days. Nora set the phone down on the sewing table beside the singer. 17 days. She was not upset exactly. That was the thing she noticed about herself in these moments. The moments that would have made another person's hands shake or their voice go tight. She became, instead, very calm. Not the calm of someone who had made peace with the situation, but the calm of someone whose entire processing capacity had shifted into a different register. The register where you didn't feel things so much as read them. Where emotion became data, and data became strategy. She thought about the shape of what Dana had done. The forgery itself was the central act. But the forgery had required infrastructure. It had required an attorney to draft the deed of trust, or someone posing as one. It had required a notary to witness and certify the signatures, which meant either a corrupt notary or a notary who had been deceived about whose signatures were being certified. It had required Ridgemore Capital Partners to accept the instrument, a private lender who had presumably done some due diligence, which meant there were people at that company who knew, or should have known, about the estate proceedings and the dual heir status. And it had required Dana to believe that Nora either wouldn't find out or wouldn't care. That last part was interesting. That was the part that told Nora the most about how Dana had seen her. Nora had always been the quieter one, the one who worked in numbers rather than words, who showed up to family events and was present but not loud, who had never in her adult life made a dramatic scene about anything. Dana had always been the one with the volume, the one who made the calls and organized the logistics and named the problems out loud in rooms. In the architecture of their sisterhood, Nora had occupied the structural role, necessary, weight-bearing, while Dana had occupied the decorative one, visible, acknowledged, assumed to be in charge. Dana had looked at her quietness and seen absence of will. That was the error. Nora spent the night in the house. She slept in her old room, the sewing room, on the narrow daybed her mother kept there for guests, under a quilt that smelled of cedar from the chest it had been stored in. She slept well, which surprised her slightly. When she woke at 6 in the morning to the sound of the mockingbird resuming its catalog, she lay still for a moment and organized her thoughts with the precision of someone laying out tools before a procedure. She needed 3 things. First, she needed a handwriting expert. Not for court, not yet, but to produce a preliminary analysis document that she could use as part of the paper record she was building. Gerald had a forensic document examiner he had used before. She sent Gerald a text at 6:15 asking him to make the call. Second, she needed to know the terms of the Ridgemore Capital Partners loan. The deed of trust would tell her the principal amount and the lender's recorded address, but she needed the actual loan agreement. The interest rate, the term, the default provisions. She needed to know how much Dana had borrowed and what she had agreed to give away in exchange. This required a more careful approach because the loan documents were not public record in the way the deed of trust was. She would need Dana to produce them as part of any subsequent legal proceeding. But in the meantime, she could search for Ridgemore Capital Partners as an entity and see what she could learn about their practices. Third, and most immediately, she needed to let the closing happen. Not because she was going to allow it to succeed, because she needed to let it reach the point at which the title company examiner, doing her job carefully, would find what was there to be found. Nora was not going to make a phone call to stop it early. She was not going to send a letter to the real estate agent. She was not going to contact Dana. She was going to stand very still and let the system work. This was the part that required the most discipline, and she knew it. The instinct, when you discovered a fraud, was to move, to confront, to stop, to name. But confrontation gave the other party time to prepare. It gave Dana time to call an attorney, to craft a narrative, to claim misunderstanding or mistake, or some other construction that would need to be dismantled at length and expense. Nora had no interest in giving Dana time to prepare. She was going to let Dana walk all the way to the closing table with her buyer and her agent and her notary into a room where a title company examiner was going to look at the title history with the specific attention that title examiners give to the last few steps before money changes hands. And that examiner was going to find the forged instrument and the non-appearing co-owner. And she was going to do exactly what Gerald had said a good examiner would do. She was going to call Nora. And Nora was going to answer. She got up and made coffee in her mother's kitchen, using the small can of ground coffee she found in the cabinet above the stove. The coffee maker was an old drip machine that had a crack in the carafes, a handle that her mother had wrapped in electrical tape sometime around 2015. Nora stood at the counter while it brewed and looked at the January calendar on the wall, with its painting of a painted bunting, a small gaudy bird, absurdly colored, that had always seemed to her like an argument against the idea that nature was subtle. She drank the coffee black. She made a list on her phone. Over the following 12 days, she did the work quietly, methodically, the way she always worked when a case was serious enough to require it. The handwriting expert, a woman named Dr. Patricia Sung, who had testified in 11 federal fraud cases, and whose preliminary analyses were considered, by the attorneys who used her, to be worth more than most people's final reports, examined scanned copies of the forged signature and 3 authenticated samples of Nora's actual signature. She sent her preliminary findings to Gerald in 4 days. Her assessment was direct. The questioned signature showed consistent evidence of drawn letter forms, with tremor-free hesitation marks at the beginning of each letter form transition, indicative of a careful copy produced from a static exemplar rather than a naturally executed signature. She could identify 3 specific points of divergence in the lowercase a of Callaway and the proportional relationship between the N and the O in Nora that were inconsistent with the authenticated samples across all 3 exemplars. In her professional opinion, the questioned signature was not produced by the same individual as the authenticated samples. Gerald scanned this and sent it to Nora with a single line. "You have your expert." Ridgemore Capital Partners, she learned through a combination of state business registry searches and public lien records in 3 adjacent counties, was a private lending entity registered in Delaware but operating primarily in the southeastern United States. They had recorded deed of trust instruments against 14 properties in the past 3 years. Of those 14, 6 had gone to foreclosure proceedings, 2 of which had resulted in the lender acquiring the property at auction for significantly less than the outstanding debt. Their interest rates, as recorded on the public instruments, ranged from 14 to 22%. They were not predatory in the criminal sense. They operated within the outer limits of what state usury laws permitted for private commercial lending. But they were, Nora thought, the kind of lender who knew exactly what kind of borrower came to them and why, and what the most likely outcome would be. She found the registered agent for Ridgemore Capital Partners and noted the address. A law firm in a city 3 hours away. She filed all of this in a folder on her laptop labeled, without drama, Ridgemore. On day 9, Bree sent her an update. The closing had been moved up 2 days, to day 15. The buyer's lender had completed their underwriting faster than expected. Everything was on track. Nora thanked her. On day 12, Gerald called with something he'd found in his own title research. The estate proceedings, he told her, had not been formally noted as a lis pendens against the property, a notice of pending legal action that should have been recorded with the county to alert any subsequent parties to the estate's status. This was Holt's omission. A minor procedural failure, but it meant that a title search run by Ridgemore Capital Partners at the time they'd accepted the deed of trust would not have turned up a formal flag. They could argue, if pressed, that they had done due diligence and found nothing to indicate a competing interest. "So they have a defense," Nora said. "A partial one. They still should have run a full probate search given the nature of the instrument, and they should have verified the identity and authority of both signatories. There's a question of professional negligence there that will cost them money to litigate regardless of the outcome. I want them in the room." Gerald was quiet for a moment. "You want to name them in the fraud claim. I want every party that touched this transaction to understand what the transaction was." "Okay," he said. "We can do that. It'll slow things down, but it builds the perimeter." She thought about perimeters. In her work, a perimeter was the full boundary of a fraudulent scheme, the outer edge of everyone and everything involved. Building the perimeter took longer than going directly for the center, but it was the difference between a conviction that stuck and one that got reduced to a paperwork error. She had seen enough paperwork errors in her career to know that they did not satisfy anything in particular. "Build the perimeter," she said. On day 14, the night before the closing, Dana called her. The call came at 8:47 in the evening. Nora was in Atlanta, in her own apartment, sitting at her kitchen table with a glass of water and her laptop open to the title documents she had been reviewing one final time. Her phone was face up on the table, and when Dana's name appeared on the screen, she looked at it for 3 full rings before she picked up. "Nora," Dana said. Her voice had its familiar texture, warm on the surface, the way a certain kind of ceiling has acoustic tile that looks soft until you touch it. "How are you doing?" "Fine," Nora said. "You?" "Good, good." A pause. "I actually wanted to talk to you about the house." Nora said nothing and let the silence stand. "I've been talking to Holt," Dana continued, "about the estate, and, it's been sitting open for a while now, which isn't ideal for anyone, and I wanted to let you know that I've been working on a solution that I think is going to be really good for both of us." She said it with the particular smoothness of someone who had rehearsed this. The phrases were slightly too polished. Not ideal for anyone. Working on a solution. The vocabulary of careful preparation. "What kind of solution?" Nora said. "I've had some interest in the property. From a buyer. Someone who's willing to pay a fair price, which in this market is actually quite good. And I thought, rather than us going back and forth about what to do with it, this could just resolve things cleanly." "You have a buyer?" "I've been in conversation with a buyer, yes." Nora looked at her laptop screen, at the title documents, with the forged instrument at the center of them like a stone dropped into still water. She thought about what it meant that Dana had called the night before the closing. She had 3 possible reasons. She wanted Nora's blessing, she wanted Nora's cooperation in some further document signing, or she was beginning to be nervous. She said, "Dana, are there any encumbrances on the property I should know about?" Dana was quiet for exactly 2 seconds. "What do you mean?" "Liens, loans, security instruments, anything recorded against the property that would affect the title." Another pause, slightly longer. "I mean, there might be some minor... Look, there were some things that needed to be addressed while the estate was open, and I took care of them, and it's all going to be resolved at closing. That's what closing is for." "You borrowed against the property." "Nora, you borrowed against the property and you put my name on the instrument." The silence this time was different in texture. Not the silence of thinking, the silence of someone standing very still because movement might make things worse. Dana said, "I can explain that." Nora said, "The closing is tomorrow." "I know, I know about it." Dana's voice shifted in a way that Nora found instructive. The warmth went out of it. What was underneath was not cold exactly, but it was real. The texture of someone who has been wearing a social posture for a long time and has just stopped holding it. "I was going to tell you. After, when everything was resolved, you were going to get your half. That was always the plan. Your plan. Our money. Our property. Nora, you know this house was just sitting there." "It was sitting there in an estate that I am the executor of." "You weren't doing anything with it. You weren't returning Holt's calls in time. You weren't making decisions. I had to—" She stopped, recalibrated. When she continued, her voice had the slightly pulled quality of someone who is trying to reassemble a tone they've lost. "I needed some liquidity. I made a decision and I should have talked to you first, and I'm sorry for that. I really am. But everything can still be fine. The sale proceeds are enough to cover the Ridgemore loan, and then some. And we split the rest 50-50, exactly like Mom wanted." Nora thought about the line of her mother's will. Neither could sell without the written consent of the other. She thought about the deed of trust signed with her forged name. She thought about the word fair, spoken in Dana's kitchen 2 years ago, with that particular inflection. She said, "Go to your closing tomorrow, Dana." A beat. "What?" "Go to the closing. I'm sure it'll be fine." "Nora, I need to know you're not going to—" "Go to your closing." She ended the call. She set the phone face down on the table. She picked up her glass of water and drank from it, and looked at the window of her apartment, where the city was doing its nighttime business. The red taillights moving along the street below, the lit windows of the building across the way, where she could see, in one window, the blue flicker of a television, and in another, the still white light of someone's desk lamp. She picked her phone back up and sent Gerald a text. She called. She's aware something may not go smoothly. Gerald replied in 4 minutes. Noted. I spoke to the title company examiner this afternoon. Her name is Carol Reeves. She has been thorough. Nora thought about Carol Reeves, a woman she had never met, doing her job carefully in an office somewhere, running a title search the way it was supposed to be run, which was a thing that most people never thought about. The network of quiet professional attention that was supposed to stand between a person and the specific kind of disaster that happened when someone decided that the rules applied to other people. Good, she texted back. She closed the laptop. She went to bed at 10:15 and slept without interruption until 7 in the morning. The closing was scheduled for 2 in the afternoon. She did not go to the closing. She was not expected to. She was the non-appearing co-owner, the ghost in the title history, the name on a document she had never signed. Her role, at 2 in the afternoon on a Tuesday, was to be reachable. She sat at her kitchen table with her phone in front of her and worked through a client spreadsheet on her laptop with the particular half attention of someone who is doing one thing while listening for another. At 2:47 in the afternoon, her phone rang. The number was a Georgia area code she didn't recognize. She answered on the first ring. The woman's voice was professional, measured, with the particular quality of someone delivering information they have practiced delivering. Is this Nora Calloway? It is. Ms. Calloway, this is Carol Reeves, calling from Sterling Title Services. I'm the title examiner on a transaction involving a property at 4114 Ridgemore Lane. Are you the owner of record on this property? I am a 50% heir and co-owner of that property under the estate of Patricia Ann Calloway. A slight pause. The sound of papers. Ms. Calloway, I'm going to need to ask you a few questions about a recorded instrument we found in the title history. Are you available to speak for a few minutes? I have as much time as you need. Carol Reeves was, Nora could tell within the first 2 minutes, exactly the kind of examiner Gerald had described. She was not theatrical about what she had found. She was precise. She identified the deed of trust, gave the recording date and instrument number, confirmed the lender's name, and then asked, in a tone that was careful in its neutrality, Miss Calloway, can you confirm whether you authorized and signed this instrument? Nora said, I did not. Another pause. Longer. You did not sign this instrument. I did not. I was not present at any signing. I was not contacted by the lender or any attorney acting on their behalf, and I have never seen or signed any document encumbering this property. I have a preliminary forensic document analysis from a qualified handwriting expert that confirms the signature on that instrument is not mine. The silence on the other end of the line had a very particular quality. Nora had heard that quality before, in the moment when a piece of financial forensics landed correctly, when a number turned out to mean exactly what you suspected it meant, and the person on the other end of the conversation had to recalibrate what was happening in the room. Carol Reeves said, Miss Calloway, I need to inform you that I have a legal and professional obligation to report this to the appropriate authorities. Are you currently represented by an attorney? I am. His name is Gerald Osai. I'll give you his contact information. She gave it. Carol Reeves wrote it down. She could hear the pen. I also want to inform you, Nora said, that I am the executor of the estate, and I have never authorized or consented to the sale of this property. The terms of the decedent's will required joint consent from both heirs. Carol Reeves was quiet for a moment. Then she said, with the specific, careful stillness of someone who has just understood the full scope of what they are looking at, I see. Thank you for calling, Nora said. Of course, Carol Reeves said. I'm going to need to pause this closing. Nora said nothing. There are some people in this room, Carol Reeves said, and there was something in the way she said people that suggested she was choosing the word with care, who are going to need to be informed of the situation. I understand, Nora said, and I'm going to be contacting the county sheriff's office, as I'm required to do when I have reason to believe that a recorded instrument contains a fraudulent signature. That's appropriate, Nora said. I would expect nothing less from a thorough examiner. There was a brief pause. Then Carol Reeves said in a slightly different register, quieter, more human. "Thank you for being available." "I've been available," Nora said. "I've been waiting for your call." She ended the call. She set the phone down on the table. She thought about Dana in that closing room. She thought about what it sounded like when a title examiner paused a closing. She thought about the moment when the buyer's agent looked at the listing agent, and the listing agent looked at Dana, and Dana understood, from the texture of the silence, that the thing she had been carrying for months, the constructed scaffolding of the deed of trust and the forged signature and the 14-day listing and the accepted offer and the moved-up closing, had reached the end of its capacity to hold weight. She thought about the specific quality of that moment when a structure collapses, not dramatically, not with noise, but with the slow, inevitable subsidence of something that had no honest foundation. Then she opened a new document on her laptop and began drafting her formal complaint to the county district attorney's office. The complaint, when Gerald reviewed it 3 days later, was 12 pages. It was precise, organized chronologically, and attached as exhibits. The title history showing the fraudulent instrument, Dr. Sung's preliminary forensic analysis, the authenticated signature samples, the terms of Patricia Ann Calloway's will establishing the consent requirement, the listing data confirming Dana's unilateral listing of the property, and the call record from Carol Reeves at Sterling Title Services. Gerald added to it a civil complaint against Dana, against Ridgemore Capital Partners for their failure to perform adequate due diligence on the borrower's ownership authority, and against the notary whose stamp appeared on the deed of trust, a woman named Phyllis Garner who operated a small notary service out of a strip mall in Claremont Hills, and who had notarized, according to her public record, 11 instruments in the past 2 years for clients with Claremont Hills residential addresses. 11 instruments. Nora had looked at each of them. She had found 2 others with signatures that she had flagged to Gerald as warranting attention. She had not said anything about this to the district attorney's office yet. She was filing it in a folder she had labeled, with her particular sense of organizational nomenclature, adjacent. Dana called twice in the 3 days after the closing. Nora did not answer. She received a text on the second day that said, "Nora, I need to talk to you. Please, just answer the phone." She read it. She set the phone down. She received on day 4 a call from an attorney she did not recognize, a man whose name she looked up while he was introducing himself and found to be a general practice attorney with a small firm in Dana's county, who did mostly family law and occasional civil work. He said he was calling on behalf of Dana Ellison and asked if Nora would be willing to discuss a resolution. Nora told him her attorney was Gerald Osai, and that any communications regarding the matter should go to Gerald directly. He said he understood, and that Dana wanted Nora to know she was very sorry, and that this had never been meant to. He stopped here, and Nora had the impression he was reading from something Dana had written, "cause harm to the estate or to Nora's interests." Nora said, "Please contact Gerald Osai." She ended the call. On day 6, the county sheriff's office called her to schedule an interview. She and Gerald went in together the following Thursday morning. The detective who interviewed her was a woman in her 50s who had the patient, particular attention of someone who had taken a lot of statements from people who were trying to explain complicated things simply. She listened without interrupting. She asked her questions in order. At the end, she thanked Nora for the documentation and said that the level of organization of the materials was, and she paused slightly here, very helpful. Nora said, "I've had experience preparing materials for legal proceedings." The detective looked at the folder in front of her. 12 pages of complaint, indexed exhibits, tab-separated sections. She looked up at Nora with a slight expression that was not quite a smile. "I can see that." The criminal investigation was not Nora's to manage. She had done what was hers to do, filed the complaint, provided the materials, been available and precise. What happened next was the state's business. Dana had, she learned through Gerald, who learned it through the professional network of attorneys who shared information carefully, retained a more serious lawyer than the general practitioner from Claremont Hills, a criminal defense attorney from Atlanta with a specialty in white-collar matters. He was good. Gerald knew him. He said, without editorializing, that he was thorough. Nora thought, good. She wanted it to be hard, not cruel. She did not have access to cruelty as a motivation, which had sometimes struck her as a deficiency, but which she had come to understand was actually a source of precision. Cruelty wanted pain. Precision wanted accuracy. She wanted every single element of what Dana had done to be fully and accurately accounted for. In documentation, in legal record, in the institutional knowledge of every professional who had touched this transaction. She wanted there to be no version of events in which the fraud had been a misunderstanding, a family miscommunication, a failure of communication between two sisters who had different ideas about an estate. She wanted the record to be complete. The civil proceeding moved faster than the criminal one, as it generally does. Gerald filed the complaint in the Superior Court on a Thursday. The defendants, Dana, Ridgemore Capital Partners, Phyllis Garner, the notary, were served over the following 2 weeks. Ridgemore Capital Partners' response, filed through their Delaware counsel, was essentially what Nora had predicted. They asserted that they had conducted reasonable due diligence and had relied on the representations of the borrower, had no knowledge of the estate proceedings, and had a recorded instrument that was, in their view, legally valid and prior in right to any competing claims. Their counsel was, Gerald told Nora on the phone one evening, billing at a rate that suggested they were genuinely worried. "Good," Nora said. Phyllis Garner, through her own counsel, was pursuing a separate strategy. That she had been presented with what appeared to be valid identification for both signatories, had followed her standard procedures, and had no basis to know that one of the persons presenting identification was not the person named on the instrument. Her attorney, Gerald noted, was considerably less expensive than Ridgemore's, which was itself a data point about the relative legal exposure of each party. "She's going to cooperate," Nora said. "Probably," Gerald said. "Her best outcome is a fine and a suspension. She doesn't want to be in the same boat as Ridgemore." Dana's defense, as articulated in the civil response filed by her new attorney, was nuanced, and Nora had read it 3 times, with the attention she gave to things that were technically well constructed. The argument was essentially this. Dana had acted in good faith as a de facto property manager in the absence of Nora's timely involvement in the estate, had secured a short-term loan to cover property maintenance costs and property taxes during the estate proceedings, had made every effort to ensure that the ultimate proceeds of any sale would benefit both heirs equally, and had been prevented from obtaining Nora's formal consent by Nora's consistent failure to respond to the estate attorney's communications in a timely manner. Nora read this paragraph twice. The consistent failure to respond to the estate attorney's communications? She thought about the 3 weeks between Holt's email and the day she had driven to Ridgemore Lane. She had told Holt she needed more time to review. She had been, in that period, working 2 active client engagements, and had answered every one of Holt's follow-up emails within 48 hours, with a request for additional time. She had been responsive. She had simply not signed. But she understood what Dana's attorney was doing. He was building a narrative in which Nora's legal caution, her entirely appropriate executive exercise of her executor's prerogative to review documents before signing them, became, in the retelling, a species of negligence that had forced Dana's hand. It was a narrative that required you to believe that the appropriate response to a co-owner's slowness in responding to estate documents was to forge the co-owner's signature on a loan instrument. It required a particular kind of logic, but Nora had read enough fraud defenses to know that the logic did not need to be convincing. It just needed to create enough complexity to negotiate with. She called Gerald. She said, "I want every email between Holt and myself for the past 8 months. Gerald said he would subpoena Holt's records. She said, "I also want a record of every property tax payment on that property since my mother's death. Who paid them? When?" Gerald was quiet for a moment. "You think she actually paid the taxes?" "I think her attorney is going to claim she did, which means she might have, which means I want to know the amounts and compare them to what she borrowed from Ridgemore." Gerald's laugh was brief and quiet. "Ho, pull the tax records." She also, in the following 2 weeks, did the thing that she had not previously needed to do, because the civil proceeding and the criminal investigation were moving on their own tracks, and her role was primarily that of the originating complainant. She pulled Dana's financial records as they were available through public sources. Court filings, UCC lien searches, county tax records, the public portions of the Claremont Hills property record. She built a picture. the picture was detailed. The restaurant failure had been more significant than the passing references Dana had made over the years had suggested. Marcus's investment had been not from savings, but from a HELOC, a home equity line of credit secured against the Claremont Hills property. When the restaurant closed, the HELOC balance was outstanding, and the line had been closed by the lender. They had refinanced the primary mortgage to absorb the HELOC debt into a new 30-year term, which had reduced their monthly payment but extended their exposure significantly. The property taxes on the Claremont Hills house, which was assessed at considerably more than the family home, had indeed increased, and there was a judgment lien filed by a contractor, a kitchen renovation that had been half completed and then stopped, for reasons the public record did not specify. Dana and Marcus were not ruined. They were not destitute. They were in the specific financial condition of people who had made a series of optimistic decisions that had failed to produce their expected returns, and who were now standing in the gap between what they needed and what they had, trying to keep the structure upright by whatever means were available. The family home had looked like a means. Nora looked at the financial picture for a long time. She did not feel sorry for Dana. She noticed that she did not feel sorry for Dana, and she examined that fact with the same precision she brought to everything else, to see if there was anything in it that needed to be questioned. There wasn't. Dana had not been desperate. She had been impatient. There was a difference. Desperation produced a kind of franticness, a loss of strategic coherence, a willingness to take actions without considering their consequences. Dana had been careful. She had found a private lender. She had forged a signature that required studying a model. She had listed the property with a professional agent and accepted an offer and scheduled a closing. She had been, within the criminal framework she'd constructed, methodical. The closing call to Nora the night before had been the only sign of nervousness, and it had come too late. Impatience, Nora thought, was in some ways a more troubling motive than desperation. It implied that Dana had weighed the risk and decided it was acceptable. It implied a calculation in which the probability of being caught, or the consequences of being caught, had been assessed and found to be manageable. Nora intended to demonstrate that the assessment had been incorrect. The criminal process moved through its phases with the institutional gravity of a thing that, once started, moves under its own weight. A grand jury was convened. Gerald, who had a professional relationship with the assistant district attorney assigned to the case, told Nora in careful terms that the evidence was straightforward, and that the outcome he would anticipate was an indictment on charges of deed fraud, forgery, and theft by deception, the last charge relating to the securing of funds from Ridgemore Capital Partners by fraudulent misrepresentation of ownership authority. The indictment came on a Thursday morning. Gerald texted her the case number. She saved it in the Ridgemore folder. Dana called her again that evening. Nora did not answer. She watched the phone ring from across the room, standing in her kitchen with a glass of water, and she waited until it stopped, and then she turned back to the window and looked at the street. She was not thinking about Dana. She was thinking about Carol Reeves. She had found Carol Reeves' professional profile on the Sterling Title Services website. A small headshot, a brief bio that noted 22 years of experience in title examination, a professional certification from the American Land Title Association. A woman who had done this work for 22 years, and who had, on a Tuesday afternoon, looked at a title history with the attention it deserved, and found a forged instrument, and made a phone call that most people, Nora supposed, never thought about. Most people thought about the dramatic moments, the confrontation, the courtroom, the arrest. They did not think about the woman in the office who looked at the document numbers carefully and then picked up the phone. Nora sent Gerald a note that she wanted to write a formal letter of commendation for Carol Reeves to be sent to the director of Sterling Title Services. Gerald replied that this was an unusual request. Nora replied that she was aware it was unusual. Gerald drafted the letter. Nora signed it. It was sent. The civil case, which would take considerably longer than the criminal one, moved into discovery. Ridgemore Capital Partners produced their file on the loan. Gerald reviewed it and called Nora to discuss it. The file showed that Ridgemore had conducted a title search through a vendor in a state 2,000 miles away, a vendor whose services were, Gerald noted with the careful precision of someone choosing not to say a ruder thing, economically priced. The search had returned a basic chain of title going back 40 years, and had noted the current ownership as being in the estate of Patricia Ann Calloway, with no further detail about the estate's legal status or the identities of the heirs. The loan officer who had processed the application had accepted the deed of trust on the basis of this incomplete search and Dana's representations about the co-owner's consent, representations for which there was apparently nothing in the file beyond Dana's signature on a standard borrower certification. "They took her word for it," Nora said. "Effectively, yes. On a loan secured against an inherited property in an open estate." "The loan amount was $420,000, Gerald said. Nora was quiet for a moment. She had known from the deed of trust that the amount would be significant, but hearing the number stated plainly had a particular quality. Her mother's house. The house on Ridgemore Lane, with the open wall and the January bird calendar and the cracked coffee carafe? $420,000. What was the asking price for the sale? $685. The math was not complicated. $420 to the lender. $130 or so in selling costs, agent commissions, and closing fees. That would have left, in Dana's arithmetic, approximately $130,000 to split between two heirs. $65,000 for Nora. Not an inconsiderable amount. Nora was not a person to whom $65,000 meant nothing, but a number that was considerably smaller than half of $685, which would have been $342,500. The difference between $342,000 and $65,000 was a number that had a name. The name was $420,000, minus interest, minus Ridgemore's fees, minus whatever the loan's term had already accrued. Nora thought about the word fair again, used in that kitchen 2 years ago. She thought about the estate attorney Holt and his too-tight collar, and his apologies for the document's length. She thought about the fact that the will's consent requirement had been one of the clauses Holt had apologized for spending time on, because it was a somewhat unusual provision, not standard in simple estate documents, but something their mother had specifically requested after a conversation she'd had with a neighbor whose family had experienced exactly this kind of dispute. Their mother had known. She had known, in the particular quiet way that mothers know things without addressing them directly, that this was a thing worth guarding against. She had sat in Holt's office with her too-tight collar, and she had said she wanted the consent requirement in the document. And Holt had probably said, of course, and typed it in. She had signed it, she had gone home, she had been dead for 4 months. Nora stood in her kitchen and held the number in her mind. Then she told Gerald to add a claim for unjust enrichment to the civil complaint. If Ridgemore had dispersed the loan proceeds to Dana, and Dana had received $420,000 on the basis of an instrument that bore a forged signature, an instrument that never should have been valid, then the disbursement itself represented a benefit that Dana had received at Nora's expense, as co-owner of the encumbered property. Gerald said that was supportable. She also asked him about a specific provision of Georgia property law that she had been looking at for 3 days. The right of a co-tenant to seek an accounting of all rents, profits, and proceeds received by another co-tenant from the shared property. Dana had received the Ridgemore loan against a property that Nora co-owned. She had not shared the proceeds with Nora. She had intended to pay Nora $65,000 after selling the property for $685,000. The difference between what Nora was owed as a 50% co-owner and what she would have received constituted, under the co-tenant accounting doctrine, a misappropriation of her property interest. Gerald said, "You've been doing research." "I've been doing what I do," Nora said. "You know most of this would be calculated at the damages stage." "I know. I want it pleaded now. I want the full picture in the complaint." He asked her about settling. It was the question she had been expecting him to ask eventually. The question that attorneys always had to ask, because it was their professional obligation to raise the option that most clients, at some point, found appealing. The Ridgemore defendants had, through channels, indicated a willingness to have a preliminary conversation. Dana's attorney had, according to Gerald, called twice. Nora thought about this for approximately 4 seconds. She said, "There is one condition under which I would discuss settlement." Gerald said, "What is it?" She said, Dana pleads guilty to the criminal charge. Gerald was quiet for a long moment. That's not standard. Civil and criminal are separate tracks, linking settlement to a criminal outcome. Is my right, Nora said. I'm not threatening a criminal outcome. The criminal process is proceeding on its own. I am simply saying that I will not engage in civil settlement discussions while the criminal matter is unresolved, because I am not in a position to evaluate the full scope of the situation until the criminal record is established. She heard Gerald processing this. That's going to read as pressure. It's going to read as a decision made by an executor who is taking her fiduciary responsibilities seriously and cannot in good conscience agree to any resolution that doesn't establish the factual record. A pause. Then, that's what I'll tell them. The hearing on the criminal matter was set for a date 4 months out. Nora went back to her work. The client spreadsheets, the financial forensics, the careful reading of numbers that told stories about what people had done with money they were supposed to account for. She went back to the work, and she was good at it. And the days passed in the particular rhythm of someone who has set a process in motion and has the patience to let it run. She drove to Ridgemore Lane one more time in the interim. She parked in front of the house and sat in the car for a moment, looking at the front porch, the overgrown rose bush beside the steps that her mother had planted in 1994 and that required cutting back every spring and that no one had cut back this year. She went inside. She had not been back since the night she had sat in the sewing chair. The house was the same. The January calendar, the cracked carafe, the open seam of drywall compound on the hallway wall. The brass floor lamp was still on. She turned it off, and the room changed from warm gold to the flat afternoon light coming through the windows. She stood in the living room for a while. She was not here for sentimentality. She was here because she had a practical task. As executor, she needed to get the estate properly organized. She had, finally, signed the transfer documents that Holt had sent her, the legitimate ones, the ones that formally placed the deed in both heirs' names as the estate progressed toward resolution. The forged deed of trust was the subject of the civil proceeding, and its status as an encumbrance on the title was frozen pending the court's resolution. The estate could not close until the civil matter resolved. It would be a long time before the house could be legally sold or otherwise disposed of. In the meantime, the property taxes were her responsibility as executor. She had paid them out of the estate account that Holt maintained, a relatively small sum, manageable, quarterly. She had arranged for the lawn service that her mother had used to continue their contract. She had called the contractor whose number she had found in her mother's kitchen junk drawer, on a business card that her mother had kept for 6 years apparently, and asked him to come give her an estimate on finishing the wainscoting repair. He had come, looked at the wall, and said it was a straightforward job, 2 days at most. He had given her a number that she had told him was acceptable. He would start next week. She stood in the living room in the flat afternoon light and looked at the floral sofa that had aged from cream to the color of weak tea. And she thought that at some point, not now, not for a long time, there would be a decision to be made about this house. Whether to keep it, whether to sell, whether to do something else entirely. She did not know what that decision would be. It was not a decision she needed to make today. What she needed to do today was make sure the contractor had her contact information, and make sure the lawn service had been billed correctly, and make sure the estate account had sufficient funds for the next quarterly tax payment. She did these things. They took 45 minutes. She turned the brass floor lamp back on, because the flat afternoon light had made the room look sad in a way she did not particularly care for. And the warm gold of the incandescent bulb restored something to it that she could not entirely name. Then she left. The criminal hearing, when it came, was not dramatic. Most legal proceedings, in Nora's experience, were not dramatic. They were procedural. They moved through their phases with the steady, unglamorous weight of a thing being done correctly. Dana appeared in court with her criminal defense attorney, and the assistant district attorney presented the evidence, and the judge reviewed the materials, and the defense offered its arguments, which were essentially the same ones from the civil response: good faith, family miscommunication, timely response issues, and which did not, Nora could see from her seat in the gallery, appear to be landing in the way that Dana's attorney had perhaps hoped. The evidence was, as Gerald had predicted, straightforward. Dr. Sung testified. The recording was played, the exhibits were introduced, The timeline was established. Carol Reeves testified about the events of the closing, what she had found in the title examination, the specific nature of her concern, the phone calls she had made to Nora, the police calls she had made afterward. She testified in the measured, factual register of someone who had done her job and was describing it. Dana sat at the defense table, and Nora watched her without expression. She had not seen Dana since before their mother's death, almost 5 months ago now. Dana had gained a slight tension in her face that had not been there before. Not age, not illness, but the specific musculature of prolonged stress, of a face that had been holding itself carefully for a long time. She was wearing a dark blazer. Her hair was done. She had the appearance of someone who had made an effort, because making an effort was the thing you did when a situation required it. Nora noted these things without particular feeling. After the testimony, the judge read through the documents one more time in a silence that lasted approximately 3 minutes. Then he looked up and addressed the courtroom with the particular register of a person who has arrived at a conclusion and is about to state it. The motion for dismissal was denied. The case would proceed to trial. Dana's attorney requested a brief recess, which was granted. In the hallway outside the courtroom, Nora stood beside Gerald with her hands at her sides and looked at the door through which Dana had walked with her attorney. Through the glass panel, she could see them talking. The attorney's posture, the particular slightly forward inclination of someone who is managing information that is changing. Gerald said quietly, "She'll look harder at the plea now." Nora said, "She should have looked at it before." Gerald looked at her sideways. "You want her to take it?" Nora thought about this. "I want her to decide." She said this, and she meant it precisely. She did not want to force an outcome. She wanted the situation to have done the work of creating an outcome. She had not made a phone call to Dana. She had not confronted her. She had not, in the conversation the night before the closing, given her any information that changed what was going to happen. She had said, "Go to your closing," and Dana had gone. What happened at the closing had not been Nora's act. It had been Carol Reeves's act, and the county sheriff's, and the district attorney's, and ultimately the system's. The collective, institutional mechanism of a society that had decided, at some point in its legal history, that property rights mattered enough to be defended by more than the goodwill of the people involved. Nora had simply made sure she was reachable when the phone rang. She went home that evening. She made dinner, rice and chicken, something that required attention without requiring creativity, the kind of cooking that kept the hands busy while the mind worked. She stood at the stove and stirred, and thought about the progression of events and what remained. The civil case would take longer. Ridgemore Capital Partners would fight. Their defense was expensive, and their attorneys were good. And good, expensive attorneys were paid to make things take as long as possible, because time in civil litigation was a resource that favored the party with more money to spend on it. But Gerald was thorough, and the evidence was clean. And the legal theory that Ridgemore had a duty to verify ownership authority before recording a security instrument against a property in active estate proceedings was defensible. The notary, Phyllis Garner, had, as Gerald had predicted, opted for cooperation. She had given a deposition in which she described the signing event with a level of detail that was, Nora thought, either genuine memory or very well-prepared testimony. And that told a story in which she had been presented with what she had believed were 2 valid state IDs and had proceeded accordingly. One of the IDs had apparently been Dana's own. The other had been, and here the story became interesting, a fraudulent ID bearing Nora's name and information with a photograph of a woman who was not Nora. Someone had made a fraudulent ID. This was not a small thing. This was not a family improvisation. This required either a criminal connection or a considerable amount of carefully directed effort. Gerald had flagged this to the district attorney's office, who had included it in the indictment as an additional charge, identity fraud, which in Georgia carried its own sentencing range and which, stacked on top of the deed fraud and forgery charges, changed the legal calculus significantly. Nora had looked at the additional charge in the indictment for a long time. She thought about Dana standing in her kitchen calculating out loud. She thought about the fact that the fraudulent ID meant planning, not impulse. Not a moment of poor judgment, but a sequence of deliberate preparatory acts. You did not produce a fraudulent ID by accident. You sought one out. You paid for it, or traded for it, or found someone who could provide it. You used it in front of a notary, and you watched while the notary stamped the document, and you took the document away with you. She thought about the restaurant that had lasted 14 months. She thought about the refinanced mortgage and the HELOC and the contractor's judgment lien and the quarterly tax bill on the Claremont Hills house. She thought, Dana had been in this for a long time. This was not a decision made in desperation. This was a plan. She turned off the stove. She plated the rice and chicken and carried it to the table and sat down and ate it with the specific mechanical thoroughness of a person who understands that the body needs fuel regardless of what the mind is doing. Then she opened her laptop and pulled up a new spreadsheet. In column A, she listed every monetary element of the fraud she could quantify: the Ridgemore loan balance and accrued interest, the prospective selling proceeds that would have been diverted, the cost of the civil litigation to date, the property management costs she had incurred as executor, the forensic document examination fee, Gerald's fees to date, the estate's costs associated with the delayed resolution. In column B, she listed the legal remedies available for each: the fraud damages claim against Dana, the negligence claim against Ridgemore, the recovery of attorney fees under Georgia's fraud statute, the civil RICO potential if the fraudulent ID production connected to any broader pattern. She did not build this spreadsheet for the litigation. Gerald had his own people doing the damages modeling. She built it because it was the way her mind worked, because organizing a situation into a structure of numbers was the way she understood it fully, the way she had learned to see things whole. She looked at the numbers for a long time. The thing she noticed when she looked at it this way was that the fraud had always been, at its core, a calculation about value. Dana had calculated that the property was worth more than what a fair split would produce for her, given the debts she needed to retire. She had calculated that the risk of the fraud was acceptable, that the probability of being caught was low, that even if something went wrong, the consequences would be manageable. She had plugged these estimates into her equation and arrived at an answer that was proceed. Every fraud Nora had ever investigated had this structure at its center: a calculation. The fraudster believed the arithmetic favored the action. What they consistently underestimated, what Dana had underestimated, was the denominator, the thoroughness of the systems designed to catch them. Not because those systems were perfect. They weren't. Holt had failed to file the lis pendens. The cut rate title, vendor had missed the estate proceedings. Phyllis Garner had stamped a document she shouldn't have. But Carol Reeves had done her job. And Carol Reeves had been enough. The plea offer went back and forth over the following 6 weeks. Dana's attorney pushed for a misdemeanor resolution. The district attorney wouldn't go below a felony plea to deed fraud, with the identity fraud charge pending. There were conversations, counteroffers, negotiations that Gerald described to Nora in brief terms that made the process sound like the movement of pieces on a board, which, in a sense, it was. Nora participated only in the decision about the civil linkage, whether she would drop the civil suit in exchange for the plea, or reduce the damages claimed, or otherwise alter the terms of the civil proceeding. She would not. The civil case would proceed on its own merits and its own schedule. The criminal process could do what it would do. If Dana pled guilty, the guilty plea would be relevant evidence in the civil case. If she went to trial and was convicted, the conviction would be relevant evidence. If she was somehow acquitted, a scenario Nora considered unlikely given Dr. Sung and Carol Reeves and the fraudulent ID, the civil case would still proceed on the preponderance of evidence standard, which was considerably easier to meet than reasonable doubt. In either scenario, Nora would receive what was hers. This was, in the end, the thing she had decided the night she had sat in the sewing chair. Not revenge, not punishment, not the satisfaction of a confrontation, just what was hers. The proper accounting of the estate, the correct distribution of the asset, the full and accurate record of what had happened. She had a mother who had left her a house and a name in a will with a consent requirement, and she had a right to both. She had exercised it. 6 weeks after the criminal hearing, on a Tuesday morning in the particular quality of autumn light that Atlanta sometimes bins, produced, cold and clear and somehow more precise than the light at other times of year, Nora was at her desk reviewing a client engagement when Gerald called. He said, "Dana took the plea." She set down the pen she was holding. felony deed fraud, sentenced to 3 years probation, mandatory restitution to the estate of whatever the court calculates, and a civil cooperation agreement that I've been told they're going to sign without modification. The cooperation agreement. She'll provide testimony in the civil case against Ridgemore if needed, and she's agreed not to contest the estate distribution going forward. Nora looked at the window. The Atlanta sky was doing its precise autumn thing, blue and sharp. The identity fraud charge, she said, reduced as part of the plea. It'll be in the record as a factual basis, but not separately sentenced. She thought about that. The fraudulent ID, the planning, the sequence of deliberate preparatory acts. In the record, but not separately sentenced. A thing acknowledged, but not fully weighted. She did not like this. Exactly. But she understood it as the nature of plea negotiations, which were not about perfect justice, but about outcomes the system was capable of producing. Okay, she said. The civil case against Ridgemore continues, Gerald said. Their attorneys made one more overture this morning. They want to discuss a structured settlement. What's the number? Gerald told her. She was quiet for a moment, doing the arithmetic. Tell them it's a starting point. He laughed slightly. I'll set up a call. She thanked him. She hung up. She sat at her desk for a moment. Then she called the contractor who was finishing the wainscoting repair at 411 for Ridgemore Lane and asked him for a progress update. He said the drywall compound on the open wall had been sanded and primed, and they were ready to install the wainscoting panels. Did she want them to match the existing paneling in the adjacent section, or had... She thought about doing something different. She said, match it. He said he'd have it done by end of week. She thanked him and ended the call, and looked at the autumn sky outside her window and picked up her pen. She had a client report to finish. She finished it.